All right, we're going to go ahead and get started and call the meeting to order. Thank all of you for being here today. We've got a number of 4 bills actually on today's agenda, and there's no rhyme or reason to the order we're going to take them, except my senator is back there somewhere behind the pole, and he and I have a thing we need to step out to together shortly. So I'm going to go ahead and take 421, and we'll follow that up with 145. Senator Pearson.
Thank you, Mr. Chairman, members of the committee. If this bill looks somewhat familiar, it's because we passed it last year nearly in this form under the guise of Senate Bill 100. Dealt with
Senator, if you don't mind, would you pull the mic? There you go.
Is it on? Okay. Dealt with the penalties for falsifying and distributing using fake ID. And unfortunately, it was assigned veto number 33, which was surprising to me. So I'll read the governor's veto for you. It says SB 100 increases all identity document fraud crimes to a felony for those over 21 years of age and decreases from a felony to a misdemeanor certain identity document fraud crimes by a person younger than 21 years. I agree with the legislative intent, but the reduction from a felony to a misdemeanor for those under 21 who are trafficking false documents is too broad. Therefore, I veto SB 100. So the change that was made is on page 2, line 5. Previously, page 2, line 5 simply said any person under 21 years of age who violates paragraph B of code section shall be guilty of a misdemeanor. We've changed that to read, as you can see, any person who's under 21 years of age and violates the provision of B of the code section for the purpose of identification be used to obtain entry into age-restricted facility or being used to purchase a consumable good that's age-restricted upon the first conviction, misdemeanor, and second or subsequent as punished as otherwise provided, which would be, in that case, described on page 1 under those items. So that's the change in the bill. The Senate saw fit to send it over 46-5. And we would request your support in this effort to send it back through again, Mr. Chairman.
Okay, thank you, Senator Pearson. We have questions from the committee. Representative Benfield.
Thank you. I'm assuming this came through our committee last year. Did this come through
It
us
did.
before?
Yes,
Okay, my apologies for not recalling the specifics. I'm just interested in what led you to introduce this bill. What's the real life, if you can give me some real life scenarios. What's the problem that we're seeking to address by this?
Well, Representative, this is just one of literally hundreds of articles, and I can make a copy available for Chairman, identifying the industry, which has become in Georgia overnight, literally, in this illegal documents. And the quality of these documents, and as being an employer, I know how difficult it is under the existing federal provisions as well as under Senate Bill 529 and using the basic pilot or Vericheck program to accept what looks like a legal document only to find out through a no-match letter 6 months or later down the road that it is in fact not legal. Matter of fact, the Atlanta Business Chronicle had front page the week after the governor's veto a story about a huge bust that was made in Cobb County where there's literally a factory creating everything from driver's license, Social Security, green cards, any kind of acceptable ID for employment purposes, and it was untold hundreds of thousands of dollars going through that thing on a monthly basis. So that's the crux of our effort here is to crack down on those who would profit from A, the manufacture, distribution, or use of it, or B, by putting employers in a very difficult, untenable situation already in a worse situation when they're accepting these things only to find out down the road that they're not legal.
Yeah, I've got a couple follow-ups. First, you referred to a term I'm unfamiliar with. No max letter?
I'm sorry, no match letter.
No match. Okay, what is that?
Simply, a no match letter is if for example, if you accept a Social Security card from someone and call in to Social Security, they're going to tell you for employment, you're using a Vericheck, they're going to tell you whether that name and that number goes together, and whether it's a valid number, meaning the person has been issued that number, or whether or not they're deceased. So once you do that, you have basically passed the Vericheck or Basic Pilot program as an employer. You've met your responsibilities under federal law and under Senate Bill 529. But say 3 months later, someone comes in and presents the exact same card and name, you're going to run it through Vericheck, and you're going to probably get the exact same answer from them. Yes, that name and that number go together and they're valid. The only problem is they won't tell you which two people standing in front of you now that goes to, if either one. That's the real life scenario. The no match letter comes when, as an employer, you will get a letter. Some people do, some don't. The larger you are, the more likely to get one that will simply say, these names and these Social Security numbers we have questions about. We've gotten them periodically. We will call the folks in. Typically, our experience has been on a letter with, say, 8 or 10 names. Half of them can be worked out. It's a clerical issue or some problem like that. They simply have to call Social Security to work it out. The other half, typically, you'll never hear from again because they weren't here legally. That was not a valid document for them. And so it doesn't mean that they're going to go back to the country of origin. It means they're going to go right down the road and get a job somewhere else and start the whole process over. So as long as these factories are out there and this industry is out there turning out the quality of document that they are, and as long as the federal government is not going to be in a position where they're going to put something as discreet as your picture on some of these documents to verify, yes, that is in fact that person, we're going to be stuck with this. And we believe the only way to remedy it to the best ability of the state of Georgia is to increase the penalties for that. So that's why we came forward with the bill.
Can I ask a couple follow-up? Really, I've got two questions that are related, and one is, what's the current federal law relating to this? And if there is a current federal law that covers this, why do we need a state law? And then what's the current Georgia law? I mean, the way I read this is current. It is against the law in Georgia. You're seeking to strengthen the penalty. Is that correct? Can this conduct be currently prosecuted under existing law in Georgia?
Well, as we're making the changes here that strengthens the penalties.
Okay, so what's the current Georgia law? What's the current penalty under existing law today? If one of these factories that produce fake IDs were prosecuted today, what would be the penalties available under existing law?
Let's see, I saw Jill here. She helped us with this, and she can, if it's outside of this code section, she can refer to it.
Okay.
As far as from the federal, I am not aware of what federal laws are in place or not in place to deal with this specific issue of the manufacture and distribution of the fake IDs.
So there could be a federal law, you're just not aware of it.
There could be, but I'm not aware of it.
Last request, if you have a copy of the Atlanta Business, I would be interested in reading that article.
Okay, it was. I will get it for you and forward it to your office. It was literally the week after. I don't know. There's not a date on this veto, but it was sometime in May. So
I can do an internet search. Thanks.
But it was in Cobb County, and it was a pretty big operation.
Okay, thank you. Oh, and I guess what our policy with Jill is we can ask her questions, but she's not obligated to answer.
That's correct.
So what's the current punishment? 1 to 5, and the change would be?
It's still 1 to 5 for manufacturing, but if you're under 21 and if you're using the ID to get into a facility that's age restricted and it's your first offense, then it's a misdemeanor.
Okay, I have more questions, but I hate to monopolize. So
come
what
back.
this bill essentially does is underage persons trying to get in, say, a bar or club?
The first time,
Okay.
it's a misdemeanor.
The way that, and I don't know whether you were here when I went over Senate Bill 100, but the bill that was vetoed, page 2, item 5, simply said any person under 21 who violates paragraph B shall be guilty of a misdemeanor. So it didn't discriminate between whether that was used to get into a club or buy beer or not. It just said guilty of misdemeanor. My understanding was the governor's office made a case that, well, if that's the situation, then they're just going to get people under 21 to do their bidding in every instance because it's always a misdemeanor. So I heard that from them too. So that's, I think, part of why they came back with this proposed change in the language.
I think it's a good change in the language in subsection 5. I'm still not clear on how this bill is addressing what I understand is your main concern, cracking down on these manufacturers. It is increasing or it is not. I don't understand how it's addressing what I think is your main concern here. Seems to be addressing underage persons with IDs, fake IDs. But how's it tackling
we have
the fake IDs for, I'm assuming, illegal immigrants?
Yeah, and I don't have my notes from the last time we went through, just the old bill. But Jill, didn't we change on, let's see, line 24, that's a change, right? The fine and the provisions there.
Actually, the fine amount, we just changed the language that 17 requires a $100,000 fine. So we just shortened that.
What's the current fine?
100,000.
So it's the same. Okay.
For that provision. I'm going to tell you, we've had a map to try to figure this out with the governor's office. Because you really, in order to understand this, and I'll be happy to give you my book, you really have to look at 1694B, and then you do a map and figure out how each of these punishments goes together with the crime. And then the overall proviso in subsection paragraph 5 having to do with under 21 to get into age-restricted facility. I'm sorry to just say that, but it is very difficult. But the changes that have been made are very similar to Senate Bill 100, but keeping in mind what the governor's concerns were, we fixed the bill.
I'm just not clear how this is strengthening existing law for the manufacture of fake IDs relating to illegal immigration. I'm just not clear on that. And then I'd also like to know what's the current punishment for a minor having a fake ID, because this would subject them to up to 12 months in the county jail as a misdemeanor. And although I think that's a serious offense, my niece got charged with that at UGA recently, and I'm just not sure if if I'd like to have her jail for 12 months for that.
She may not like you telling us that.
Yeah, I know. It's public record.
Well, I'm going to have to defer to Jill on that specific question because I didn't bring my folder from last year on this, just my folder from this year, and I apologize for that. But the penalties were increased. I believe that was the whole reason for the bill.
I'm saying the penalties aren't increased.
Well, they are increased in some ways because, like, for example, the striking on line 12, it used to be all of those offenses were misdemeanor. You see on line 13, they were all misdemeanors. And now paragraphs 1 and 2 are felonies on line 26.
So the ones on line 12, which is 1, 2, and 3 of that section, those were struck.
So
As
3 and 6 are now felonies. I'm sorry, 1 and 2
yeah,
are now
1 and 2
felonies.
on
So-
line 12.
Unless you're under 21 or unless you fall under the provision of subsection 3, paragraph 3.
Okay, and this bill doesn't give us what 1 and 2 are, so I have to pull the code to understand what we're now raising to a felony. Okay. I'm going to make a copy of that for the committee. I think that's helpful.
Are you okay for now?
I'm done. I'm
Representative?
sorry to have
Okay,
monopolized
no,
the
that's okay.
questioning.
That's okay.
Where's the bill?
We may. I'm going to recognize Vice Chairman Mumford for a question, and then we may drop this one down a bit until you and I do our thing upstairs. Vice Chairman Mumford.
I don't have a question. I think to answer the question of one of the committee members, it's already a misdemeanor to use a fake ID, and it has been for many years. So this is not a change for using a fake ID for alcohol purposes. I think this is a good bill, and I wanted to be recognized for a motion at the appropriate time.
Okay, I'm not going to recognize you quite yet for that. Is that Representative Ramsey or Everson? Okay.
Thank you, Senator, for bringing this. I too like this legislation. But on line 21, I just have a simple question here. How did you arrive at the number 3?
It was somewhere between 2 and 4, I think is. I'm sorry, we generally handle these in economic development in the Senate side, not judiciary. So,
Okay.
so it's
thank
a
you.
little joke. I'm sorry. Well, I mean, we had to have a number. We had to have a number more than 1, and so.
I was just curious as to 3 versus 2.
Yeah, I mean, again, it was just almost the same question we dealt with for the underage drinking. I mean, how many times do you get, and when is it? It's just a matter of time before the person gets there because their intent is to get to the part where there's a penalty. So, the 3 seemed like, reasonable number.
All right, thank you.
Thank you, Chairman Knox.
I'll pass, Mr. Chairman. Thank you.
Representative Doug Collins.
Good morning, Mr. Chair. On the question of 3, does it have to, do you catch them one time, they're selling 1, then you got to go 2 and 3, or is it aggregate, or do they have to catch them selling 3 at one time? Or do we need to make that language?
Well, it doesn't really differentiate here, but we're talking about. I guess you'd have to say what would be the scenario. Is it possible you're talking about a minor trying to get into a club with a bunch of friends and he has a pocket full of IDs and he's passing them out? Or is it someone who's intentionally using to distribute these for employment purposes that has those? I mean, so I guess it depends on the context.
Right. And that's where I was, as you well know, up in our part of the world, we have these going on all the time, and they're sold at, flea markets and everything else. The question is, if he could figure out it's just 1 at a time, then they would make sure they only had 1 and that it own them at any one time, especially in those areas where they're known to be, at least there's at least been a history of this kind of activity. So I was just curious if they had to have 3 on them at a time, or can this actually aggregate? When we get, if we caught you 1 with 1, we caught you another time with 1, and I know there's a possible, flight risk issue here as well. But and it's not a killer. This is a good bill, and I'm just asking that question. And maybe, somebody else, the district attorney or somebody else would like to take a swing at that.
I would, if someone who has, from a judicial standpoint, understands how this would be interpreted in a case where Jill or somebody, lawyers should only be able to ask non-lawyers so many questions in 1 hour. I mean, because I don't think like a lawyer.
And I'm your friend, sir.
Oh, I know that. Now I'm glad to make an exemption for White County and lower it to 1. If you wanna do that.
we would work on that
That'd
together.
That'd be great. But
And here
I did bring counsel with me, though.
And here I am looking forward to being with your Judiciary Committee this afternoon.
Again, I think as I read this, just as a layman reads this, my interpretation is that you have 3 or more documents on your person, and it's clear that the intent is to use them, to distribute them, sell them for gain, for the purpose of people using them fraudulently under the provisions.
So
that would be my interpretation.
And that was my plain reading as well. And I'm just not sure. And I was just wanting to make sure that was what we were wanting to do here, and there was no, there's always ways around everything. And that was just my question, because right now the plain reading, what I read as well, and you did wonderful with, is if only if they have 3 or more, do these new provisions or these higher provisions kick in. And I was just looking at the one who has 1 on him, 2 on, and it's a consistent pattern, and that's all I was looking at. But I appreciate it. Thank you, Mr.
Okay, here's what we have another question or two. Here's and I just got a pen that you and I are needed. We're going to drop this one down on the calendar today. We're going to take it back up here in a bit. Senator Pearson and I have some matters upstairs we need to attend to, and well, I don't think we are. We have other questions. So we're going to just defer this one, if that's okay with you,
Yes,
Senator.
sure.
We'll come back down. For those of you who might have an interest, I will tell you that Senate Bill 440 is going to be postponed. It will not be taken up today. That's by Senator Douglas. We'll take that up at a later date to be determined. We still have Senate Bill 145 with Chairman Smith, and we'll go into that now, and then we'll be back.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Members of the committee, I appreciate you having a hearing early this year on Senate Bill 145. Senate Bill 145 is drafted for the purpose of allowing a range of sentences for the crime of murder to include life without parole. The bill was presented last year both on the Senate side where it passed and before this committee where it received a unanimous recommendation of due pass as it was amended by the committee. And so I will ask again that you all reconsider and hopefully this time we'll be able to have a floor vote scheduled on it in 2008. When you look at Georgia's criminal code, there are certain offenses that are considered serious violent offenses. 1710.6.1, I believe, lists those offenses out, and they include what some people refer to as the 7 deadly sins, things like murder and rape, aggravated robbery, kidnapping. And when you look at those serious violent offenses, murder being considered the chief among them, the crime of murder contains 2 sentencing options in 16.6.5, I believe. And in that code section, it says that you can be, when you're convicted on the crime of murder, you will either be sentenced, you'll either be punished by death or sentenced to life in prison. And it does not say life without parole. When you look, by contrast, at the crime of rape, for example, it includes the sentencing possibilities upon conviction of death. I don't need it. Thank you. Of death, life without parole, or life in prison. And so it's always seemed a little bit odd that in the crime of murder, you don't have the possibility of life without parole, and yet the code section does set that out for rape and for other crimes. When you look at 1710.30 and the death penalty statutes, except for treason and airline hijacking, we have to have aggravating circumstances found by a standard of beyond reasonable doubt in order for the jury to be able to convict and punish someone by death. The only way for a crime to be punishable by life without parole, and I'll specifically talk about murder, is for a district attorney to, in good faith, believe that aggravating circumstances exist, and pursuant to 171030.1, they seek the death penalty, notice the crime as a capital case, go through the extraordinarily expensive and time-consuming process of pursuing a death penalty conviction, which, as you all are undoubtedly aware, means from the very beginning and the voir dire process to the very end is much more complicated and expensive than any other process in our criminal courts. And then, once that death penalty crime has been noticed, once it has been sought, absent a plea bargain in that context, a prosecutor would have to attempt to obtain the death penalty and fail to get it in order for the jury to sort of back its way into, or the court to back its way into, a sentence of life without parole. There is no way for a prosecutor, or for that matter, a defense lawyer, from the outset to believe that the appropriate sentence is life without parole and to seek that resolution of a case without first going into the difficult and complicated waters of a capital crime. And I believe that there is a role for capital punishment in our society, and I know reasonable minds disagree with that, even at this table. But there are certainly some cases where the aggravating circumstances are either not present, cannot be proven, or for a variety of other factors, including the burden on the governing authority and the desires of the victim and their family, or the victim's family, where life without parole would be the appropriate sentence. And prosecutors are left without the option of seeking that from the beginning. So what Senate Bill 145 seeks to do at its simplest core is to simply add the possibility of imprisonment for life without parole embedded into 1651, where the crime of murder is defined in its sentence. It would be parallel to the way that the crime of rape is defined in with regards to its sentence as well. That is to say, on page 1 of the substitute that passed out of the House Committee last year, on lines 19 and 20, it would say, "A person convicted of the offense of murder shall be punished by death, by imprisonment for life without parole, or by imprisonment for life." And then, in order to accomplish that, the bill goes into the other code sections. The way that 171030 and following is set up is that the death penalty statutes are first laid out, and then the life without parole track, if you will, is the point 1 that follows that. So 171030 sets up the criteria for a death penalty case. 171030.1 sets up the alternative for life without parole in the capital context. And that's true for 171031 and 31.1 and following. So what we've done is gone in this code, and that's why you see the other sections. We've repealed the 171030.1 and 31.1 code sections relating to the life without parole option in the capital context. It will still be an option in a death penalty trial. If you seek the death penalty, if you feel it's appropriate, if you pursue that and you fail to get it, and currently Georgia requires unanimous vote by the jury to a recommendation by the jury for the court to impose the death penalty. If you don't get that at trial, then the court will impose life without parole. And one thing that we worked on last year in this committee was, and we had a significant debate and discussion about this, was and in consultation with the criminal defense bar as well, making sure that the judge charged the jury with the sentencing options so that there was no ambiguity in that process. I think all of us agree, whether we agree with the sentencing possibilities or not, that there ought not to be ambiguity in what the jury is deciding. They ought not to be confused about if they're not, for example, giving someone the death penalty, there ought not to be confusion about whether or not that person will be released. Because some juries purportedly vote for death because they think if they don't, the person will be released. And so we added a jury charge in this, and you'll see that in page 4 of the substitute, lines 17 through 28, relating to the sentencing phase, where the court will instruct the jury about the meaning of the terms in the sentencing options. And then the other compromise that we reached was to make sure that, and this was in consultation with the criminal defense bar as well, that the jury, that it's clear that the jury is the one that will ultimately decide the sentence in whether that's life or death, and that they will make that the sentence of the jury. So I think that covers really what the bill does. We try to tread very, very carefully whenever we open up the death penalty statutes, and we very much appreciate the assistance of Mary Beth Westmoreland and the Attorney General's office. It's a delicate statutory area to make changes in because it has so many ripple effects with appeals, habeas, and the death penalty cases in which the rights of the defendant are so carefully weighed in our system. And I sought input from both the prosecutors, from the judiciary, and from the defense bar. I will tell you that by and large, the prosecutors are very much in favor of being able to have this as a sentencing option. It does not mean, for example, that you're opposed to the death penalty because you believe there ought to be an option for life without parole. They believe that it would be a much more efficient use of the court's time to have that on the table at the beginning as a possibility without requiring a death penalty case. The defense bar is somewhat divided. The folks that do, and certainly they may want to speak to their opinions, but in my understanding of our conversations is that those that do capital defense cases, generally speaking, are in favor of the case, of the legislation, because they believe that option will allow, in some cases, death penalties which are maybe not necessary to be noticed and pursued to result in cases which should be resolved with life without parole. And the general criminal defense bar is somewhat divided. Some feel like that prosecutors may use this as a negotiating hammer to negotiate life without parole when really life with parole is the appropriate sentence. Of course, as you all may know, last year we changed the time in which you can be paroled up to 30 years from its previous level, and that's the current state of the law now. So before you're eligible for parole, so that bar, is my understanding, they are divided on the question, and they're not. There's not a unanimity among their opinions. That being said, I appreciate the opportunity to present the bill. I think there is broad support. Last year, the committee unanimously supported a recommendation, and I think the perspectives on that were for all different reasons. But I'll be happy to answer any questions the committee may have.
Chairman Smith, I'd like to draw your attention to page 5, line 7. Indicates July 1, 2007. Shouldn't all of those dates be changed to 2008?
They should. I'm working off of last year's version of the bill because I felt like it made more sense than to work off of the as-passed Senate version. But there needs to be an update to the committee sub if it goes forward to update it for this year. We were under the mistaken impression that it might pass through last year.
All right. Would you accept the change in those dates on that page?
Yes.
It would be 7, 8, 20, 22, and 23 as a friendly amendment.
And 15.
And 15.
I would.
All right. Any objection from the committee on those changes? Hearing none, we'll have that as a friendly amendment. Then it's been accepted then. Stuckey Benfield, Representative Stuckey Benfield.
I had the same question about the dates, so I waived.
Thank you. Mr. Collins.
Thank you, Chairman. Thank you, Mr. Smith. I appreciate this legislation. I think it's been worked on a great deal. I like the fact that after some of our conversations, there is an explicit jury instruction. There's some other things in here. And, Mr. Chairman, at this point, I would just like to say I have a motion at the appropriate time.
Thank you. I'm not sure who it is down there. Nobody. All right. Mr. Levitas.
Thank you. Mr. Chairman, I'm sorry. I just want to make sure I understand, and I agree. I think this is a great bill. In repealing 1710-31.1, essentially the provisions of those have been incorporated into the new language in this bill, right?
That's correct.
Okay. That's it. Thank you, Mr. Chairman.
All right.
Just to be, I don't want to mislead you. The sections that had the prerequisites for life without parole have really been taken out, not incorporated into mine, because they're no longer prerequisites. You don't have to have a statutory aggravating circumstance to seek life without parole. Other than that, the new scheme for seeking life without parole is incorporated in the new bill.
All right. I only had one person signed up to speak on this bill. Is there anybody else that wanted to speak on the bill? All right, and the person who signed up is going to decline at this time. Do you have a motion, Mr. Collins? I'll recommend.
Yes, Mr. Chairman, I appreciate it. I make a motion with due pass on Senate Bill 145's committee substitute. I was working off LC 292909S as amended.
All right. There is a motion and a second. Is there any further discussion from the committee? Hearing no further discussion, all those in favor of the motion, please raise your right hand. Those opposed? Did you vote both ways, Mr. Knox? I'm sorry? Did you vote both ways?
Vote both ways.
You were a little slow bringing your hand down.
We were just debating if you get life with parole or you on parole for life if you want parole.
That hurts my head to think of. Thank you very much, Chairman Smith. Recognize Representative Levitas to present the computer security SB 24.
Thank you, Mr. Chairman. For the record, I explained to the sponsor of this bill that while this passed out unanimously last year, having me present it may change the fate of his bill, but he said he was ready to go forward anyway. Mr. Chairman, I bring before you LC 292890S, which was before this committee last year. As you will recall, this creates a new code section that deals with what they call internet phishing, and it prohibits people from falsely representing themselves through internet or through email as a business to get people to give identifying information about themselves, and provides for a punishment of 1 to 20 years and a fine of anywhere from $1,000 to $5,000. And the traditional kind of thing that this touches, we've all gotten those from a bank, Wachovia or First National, saying there's been a security violation, we need to get all your information, and they use that to then hack into people's accounts and steal from them. And the only other thing I have is a friendly amendment, and I've spoken with the sponsor of the bill. This is he is comfortable with it. It would be a new subsection F to be added on page 3. Subsection F to be added on after line 3 on page 2. And there should be copies in everybody's folder of that, but I will read it. It just says, no provider of an interactive computer service may be held liable under any law of this state or of one of its political subdivisions for removing or disabling access to content that resides on an internet website or other online location controlled or operated by the provider, and that the provider believes in good faith is used to engage in a violation of this subchapter. What this does is protect an information service provider like MSN from being liable if they think someone is using their account to phish, to violate this statute, that they could cut off their service and they're not going to be held liable, so they couldn't get sued.
And where is that again in the?
It's new subsection F is the proposed amendment. It would be to add it after line 3 on page 3 of the committee substitute that we passed.
Does a member of the committee make that move that amendment? So moved. All right, it's been moved and seconded. Any discussion of the amendment? It's considered a friendly amendment. If
Yes.
there's no further discussion, then that'll be an amendment to the bill.
I have nothing further, Mr. Chairman.
All right. Are
Happy
there
to
any
answer
questions from any of the members of the committee? I don't see any. Is there anyone who failed to sign up who wanted to speak on this bill?
Mr. Chairman.
Is that the amendment that he just made? All right, well, we'll get back to you in a minute. Go ahead.
I would defer to Legislative Council if you'd like. And
Do you have the same issue?
Well, I have not even had a chance to read the amendment. We have worked with Senator Staten on this bill for over a year now, and everybody agreed, the Chamber of Commerce and the Trial Lawyers Association, that we ought to just leave the civil litigation issue out of this bill. This bill intends to criminalize a practice that is harming a lot of citizens, and frankly, Chamber and the trial lawyer said, let's just withdraw our issue and let the bill go forward to do what Senator Staten wants to do with it. The amendment may be perfectly fine. I literally have not had a chance to look at it, but the idea of suddenly re-injecting immunity causes concern for us. Perhaps while Ms. Travis speaks to the committee, I could have a minute to read the amendment and then offer thoughts that may or may not suggest our concern with it.
Thank you. All right.
I can hold until Ms. Travis has a chance to respond because I
You
had
got a question on another matter? Or
no, a question about the amendment. I had my hand.
Go ahead.
My concern is why this amendment and why it's necessary in this bill.
Mr. Levitas.
The reason, Mr. Chairman, that this was introduced is
Bill.
The reason this is introduced
Put you on mic 1, right there.
was
Mic 1.
for an information service provider who's trying to make sure that an account holder is not using his or her account to violate, and after talking with counsel, rather than the subchapter, it should be part. This protects MSN from being sued, or AOL or Bell South or any of them from being sued when they find a phishing account and cut it off. It prevents them from turning around and being sued. And that's really the purpose of it. And the only other thing I would add is that perhaps what we need to say is that no provider of an interactive computer service may be liable in a civil action under any law of this state, because there may be other laws that apply, and that was not the intent. I think the only intent here is to prevent them from being sued if they cut off a phishing account.
So the idea is that you're trying to stop the person who's phishing from suing the
That's
internet
correct.
provider, not other people from suing them for allowing people to fish.
That's correct.
All right.
No, you're not preventing anybody can. We actually removed last year. There was a civil provision in here that this committee removed that would have allowed a cause of action by the trademark holder or license holder against the person who fishes, but that was taken out. So really, this is just getting to the providing immunity for the information service provider from being sued by the person whose account is cut off.
All right. What's the origin of the term fish?
PHISH. You'd have to ask somebody else. I just know it's out
We have a
there.
tech graduate here probably knows the answer.
Yeah, I went to Georgia. We don't do things like that.
Go ahead.
Mr. Chairman, thank you. I've now had a chance to read it, and I believe Representative Levitas is correct. This actually would provide an additional tool in the effort to stop phishing. It would allow the service provider to stop their access, to block their access to the content that was enabling them to fish, and would, I guess the only person whose cause of action this would thwart would be the fisher, and so we certainly would be in agreement with that. And I went to Georgia, and we spell fish with an F, so I can't help you there. But we have no objection to the amendment, Mr. Chairman. Thank you for the
All right. Now,
opportunity.
there was a suggestion by council to change.
There was what I would request of the committee is for somebody to restate or restate the motion or provide a substitute if it's already been incorporated.
What I was going to suggest is we just have another amendment.
Okay.
to
Well,
make
the amendment would be the same. My amendment would be that it be the same as in the members' folders, with two exceptions. After the word libel on line 1, we put it the words in a civil action, and that meets with councils. And then to change the very last word from subchapter, as council points out, there is no creature that is a subchapter here, so to use the word part, since part 4 is what this bill addresses.
All right. Is there a motion from a member of the committee to make that amendment? There's a motion, and is there a second? I heard a second. Is there any further discussion of the matter? Before we vote on it, Jill, are you satisfied? You understand that? You can make that change? All right. That is a friendly amendment you're
Yes.
accepting? All right. That'll be an amendment to the bill. Like Leviticus 2. And I want to thank Mr. Clark for coming in here and giving us that information. All right, I don't have anybody else signed up. Was there anybody else that wanted to speak on this or the origin of the term fish? Hearing none. Is there a motion regarding this bill? There's a motion do pass. Is there a second? It's been seconded. All those in favor, please please raise your right hand. Appears to be unanimous. All right, let's come to order, please. Let's come to order. Come to order, please. All right. I understand there's been some conference while we took a brief break. Is there an amendment to be offered?
Yes, Mr. Chairman.
Let me make sure I got your mic.
Got me now. All right. Offer an amendment on line 7, and it's after the as, correct? Okay. From after as, page 2, line 7, after as, strike to the period, add for a misdemeanor of high and aggravated nature. Shall be punished as a misdemeanor for high and aggravated nature. Yes.
Okay, is there a second to that amendment? Second. There's been an amendment and a second. Does the author of the bill accept the amendment? It's a friendly amendment?
I'm just overjoyed with that amendment.
You're lucky to get out of here with just that. All right. There's then all those in favor of the, is there any further discussion on the amendment? All those in favor, please raise your right hand. Those opposed? All right.
Yeah. I thought we did have a motion, didn't we? I thought we had a motion already on it. Wait. Here's the motion.
Okay. Just to clear it up, we're going to do a reading. All right. Is there a motion on the bill? Yeah. All right.
Second.
Second. Yeah. I just had a question I wanted to ask about the bill. Right. All right. Go ahead.
If I could, or Jill, maybe you can answer this for me. My question has to do with page 1. Before we get into subsection 3, when we talk about 3 or more identification documents. Now, my question is this: if the person was here in our country, just for the sake of this conversation, illegally, and had a matricular consular card in their pocket that said that their name was John Q. Public, whatever that name may have been, and they had 2 additional false documents that were forged documents for like a school, a social security card, or a driver's license, would the 3rd document, even if it was not issued by the same person representing that person's image, identification, and name, claiming to be the same person, be counted as the 3rd document? So that could even mean a Sam's membership card. And that's a concern, because I think the intent of the author was to catch someone who was trafficked who carried multiple documents. But if the person had a Blockbuster card under the name Juan Gomez, a Sam's card.
He said subsection 3, but I don't think that.
And you correct me if I'm wrong, it's just a question. I understand. I'm looking at the code section right here. But when we changed the penalties.
No, sir, you haven't.
Yes, we do. Which section are you on?
He's right here on 3. Something like this right here. 3 or more identification.
Okay.
So the $100,000 or both isn't a change?
What is
923, the amount specified by code section 1710A. If you go to 1710A, it says $100,000.
Okay, I'm sorry, I'm looking at 1694. But which was what we were amending originally.
What?
1694 this is from 1694, we're in subsection C, but subsection D is a violation.
Are you looking at this, John?
Oh, I am.
Okay.
Online.
Okay, you're looking. Okay.
You're looking at a different document than we're looking
I'm
at.
looking at Georgia Code Online, LexisNexis.
What this bill addresses is subsection C.
I would draw
talks
the
about
question when I read the
punishment
paper
for
version.
violation of subsection B. So subsection, you're on the right part. Subsection B is the violation itself, not the punishment.
All right. Question's been withdrawn or answered. I'm not sure which. Just a moment. I'm going to get to you, but I think Mr. Levitas, you were first.
No.
All right.
I think this might be helpful. I read through this about 5 times, and I think I've got this right. If you look at the white paper, what we're changing is subsection B, subparagraphs 1 through 6. Okay. Subsections 1 and 2 are currently misdemeanors. They are going to be changed to a felony punishable by 1 to 5 years and up to $100,000 or both. Subsection 3 remains a misdemeanor except for a second offense, which will be a felony. Well, we just changed that to a misdemeanor of an aggravated nature, but that kicks in. No, the second offense is a felony. Okay. Okay. That remains on. Subsection 3 remains unchanged. Subsections 4 and 5 would also be elevated to 1 to 5 years and up to $100,000. Is that not? There's 1 to 5 years? Okay, so what are we changing? Was I right about subsections 1 and 2 being changed to 1 to 5 years?
Unless the person's under 21.
Okay, so So what this bill changes is subparagraphs 1 and 2 that are currently misdemeanors, and they shall now be 1 to 5 years and up to $100,000. No?
That's the way the bill reads, but we're going to amend that to a high and aggravated with a motion.
I mean, as I read this, the sections, there's two things. There's subsection B, which is the violation of the statute. Then there's subsection C, which is what this bill addresses, which is the punishment provisions for violating subsection C of 1694. Everything that is not either struck through or double underlined is existing law. So in existing law, a paragraph 1 is a misdemeanor. In existing law, paragraph 2 is a felony. And that's and same thing with paragraph 3. Not according to the way this is drafted. Paragraph 2, C2 has that it shall be punished for a felony. Right. And okay.
Okay, the way I read this, on the white paper, which is what we're amending with the bill, subsections 1 and 2 are currently misdemeanors, and they're now going to be elevated to felonies punishable by 1 to 5 years and up to $100,000. Is that correct, Jill? Okay. It says it's a misdemeanor. Current law, it's a misdemeanor, so it can't be punishable by more than 1,000, can it? By law?
That's a question we'll direct to council in a moment. All right. Jill, I know you were tied up with Mr. Levitas, but I believe there was a question asked, and the question was if it was a misdemeanor before, it didn't have a $100,000 fine on it.
Correct.
All right, and
I thought you said current law it's 100,000 for subsections 1 and 2.
No, your sentence was now it's punishable by up to $100,000 fine, and my response was the law was $100,000. I thought you were trying to illustrate the difference.
So what this bill is doing, subsections 1 and 2 are currently misdemeanors, punishable under current law up to 12 months or a max of $1,000 fine or both. This change would now allow a punishment, felony punishment, 1 to 5 years or up to $100,000. Okay. So then my concern on a policy, now that I understand exactly what it does, is a policy matter. Do we want to have a second, have a violation, an adult knowingly possessing a false document? Do we want that punishable by up to 5 years in prison or $100,000 fine for a first offense? That's a policy issue. That's what we're deciding here, and that to me seems harsh. And I guess I'm asking the author of the bill to argue why you would like that change in the law, to explain to me why you think that would be an appropriate sentence for, say, the Blockbuster video card. I mean, I know what you're trying to get at is the illegal immigrant issue, and I understand that, but it also, I mean, we have to look at the unintended consequences. Do we want someone potentially being prosecuted as a felony with 1 to 5 years and $100,000 for having a fake ID first offense? I know we're talking about adults only.
Yes, please.
Well, I'm just thinking
I guess in reference to the Blockbuster video card, that would not be accepted as a legal identification in an employment situation, or probably even under Section 5 as access to club or buying alcohol. The question prior as to is that excessive? We've tried to say 3 or more documents to make sure that it's not somebody who just has his driver's license and maybe his wife's in his pocket too, but that they are specifically, out there with the intent to manufacture, distribute, or use this for these purposes. That's on line 20, 21. Mm-hmm.
So a first offense of a person having a fake driver's license, adult, would not be a felony? I mean, the way I read this, a first offense for an adult having a fake driver's license would be a felony punishable by 1 to 5 years or up to $100,000. And I'm not saying that shouldn't be a crime. What I'm questioning is, I think it would be more appropriate to keep that as a misdemeanor, not a felony. One ID, an adult having a fake driver's license, one fake driver's license. I think the current law is a misdemeanor. I think that's an appropriate sentence. I think it's my opinion. I think it's excessive to have 1 to 5 years and up to $100,000 for a first offense.
Well, unless, Jill, correct me if I'm out of line here, unless it's referenced somewhere else in this code section differently, starting on line 19, any person who manufactures, sells, distributes, delivers, receives, possesses, or offers for sale, the 3 or more. So I guess simply possession in and of itself is what you're concerned with there. As not being a lawyer, not dealing with what the district attorneys have to make the determinations of what is presented with them. Do we go forward and press a charge under this? I believe the circumstances around would have to at some point dictate, besides just having 3, is there a cause to charge under these provisions, and can we get a conviction on it? Am I incorrect with that? I mean,
let me try to respond to that. I think you need to keep in mind that there's really nothing preventing, I don't think, prosecution for forgery under the current law to present a fake identification, which was it carried 1 to 10 now? 1 to 10 maybe, something like that.
But this gives a misdemeanor. Existing law provides a misdemeanor option, and this is doing away with that misdemeanor option, which gives prosecutors less options. Or am I reading it wrong? I'm not a prosecutor, but that's the way I read it. Is it's actually giving prosecutors less options.
The policy is the policy is line 12. You see the number 1 is stricken, and now on line 26 it appears. And it's B1 is knowingly possess, display, or use any false, fictitious, fraudulent, or altered identification document.
I gotcha.
So that is the policy issue.
Or-
Changing that from a misdemeanor to a felony.
I'm gonna put you down, Mr. Knox, but I recognize the distinguished gentleman from Henry County, Mr. Lunsford, for a question. You remember pushing that button?
Mr. Chairman, I do. I'm okay with the provision on that which says for age restricted facility or purchase consumable good, and I think that clarifies it. I think that on the front part, I do believe that possessing a library card, Sam's Club card, or Blockbuster card in conjunction could very possibly put you in jail, but I withdraw my concerns.
All right.
Jacobs or Abrams, either one.
The distinguished representative from Fulton County, Ms. Abrams.
Actually, nowhere near Fulton. I'm DeKalb County only.
You're a DeKalb County only?
Only DeKalb County. You guys don't know me at all, do you?
Does Jacobs have any of Fulton County?
If you use your own name,
That's my home county, so I'm all right.
I take no offense.
Straighten this out for us, Ms. Abrams.
I would say I agree with Representative Benfield's reading of the language. My concern is this: I think the intent of the author appears to be to raise the penalty for possessing a false document and to make it a felony more quickly. My concern is that by moving subsection 1, which, and I think Jill, and what I read this to say, and I think Jill just said it, subsection 4 of the bill before us, lines 25 and 26, by moving paragraph 1 into this section, you make it when someone possesses a false, fictitious, fraudulent, or altered identification document, it automatically is a felony. My concern in response to your issue of forgery tends to be the producer of the document, not the possessor of the document. So right now, simply having the document is not a felony. My concern is that this gets us to a felony too quickly, and this captures an entire range of people. And I think about those folks who have identification documents that, let's say you have a suspended license. Certainly it is a bad thing to do. I do not think it should rise to the level of a felony on the first offense. What I would recommend at the appropriate time is that we move that paragraph 1 to the section, I think it's subsection 2, which would be lines 14 and 15, so that you add paragraph 1 as something that is a felony on the second or subsequent offense. The problem is otherwise it is on the very first offense, whether you are here legally or illegally, you are guilty of a felony. And if you happen to possess a document, let's say you're 21, you have your fake ID, you go to celebrate your birthday, you use the same ID because you haven't bothered to get a real ID because you're not allowed to have a driver's license because Mr. Everson is taking your driver's privileges away. But that day, you are then guilty of a felony. And I think that's problematic. I think that's an overreach for this bill. I understand the author's intent, but I think there's a way to split the baby and to put that language in subsection 2 of this language and achieve the intent of making it a felony without making it a felony the first time.
All right. I'm going to recognize you to make an amendment at the appropriate time. I still have some, certainly.
You ought to let her speak sooner and more often because she made good sense to me.
We've recognized that for a long time down here.
Yeah.
They don't know who I am, but they like me.
Well, I did until today, and I like you even more. But I just want to make sure that we're not overlooking the fact that it's 3 or more. Does that change?
That 3 or more is a different section of the code. So what you've
you're
done
talking
is when you moved 1
and 2.
Right. So if you look at the white sheet, this one, what happened is they moved on page 1074 where it says B1. This moves that language into the felony section instead of moving it into the second and subsequent felony section. So it becomes automatically a felony on the first offense.
Okay.
And that's the problem. The 3 or more is a separate subdivision of the chapter. So that's a completely separate issue. We're looking at B1.
At B1.
Yeah. And that's
Okay. All right. Ms. Benfield, do you need to say anything else? Or are you satisfied?
She said it better.
All right.
Always does.
All right. I think I'm going to recognize, since we're having a redo, I'm going to recognize Representative Collins to make the motion on the bill, and then I'm going to recognize Ms. Abrams. Have a motion. Sorry. All right. All right. Thank you. I'm going to recognize Ms. Abrams to make a new amendment.
Okay.
Go ahead, Ms. Abrams.
I move that we amend line 15 on page 1 and insert after the word paragraph parenthetical 1, close parentheses. And then on line 26, we strike the parenthetical 1. So that line 15 would read, the provisions of paragraph 1, 3, or 6 of subsection B of this code section.
All right. Are there any questions?
Is that a problem?
Problem.
Okay.
All right.
What are you going to do for a first offense on paragraph 1? Deal with that.
Sorry, and so I would also unstrike on line 12, paragraph 1. Thank you, sir.
All right. Does everybody understand the amendment? Is there any further discussion of the amendment? It has been seconded. Does the author accept that as amendment as friendly?
But for the non-lawyer, if it would please the chair, if she wouldn't mind, or Jill, somebody going through this with me now, because I thought I understood it coming in here, and I'm really questioning now. When you get done, if we would go through this whole thing and go back and forth, so I know exactly what this bill's doing now.
I'm gonna call on our counsel to see if she can
Thank you,
restate
Mr.
what she believes it's doing.
The Abrams amendment made it first offense possession is remaining a misdemeanor. A second offense is going to be a felony, 1 to 3, $25,000 fine, and first offense is never going to be a felony. That's the change on line 26.
And that's referring to B1. Those are all B1s.
Yes, sir.
Okay, so that's all we're dealing with on page 1 is B1s.
No, that's the Abrams amendment.
Okay, her amendment on the front page deals with only B1 of the code, and the back page is the other amendment that, right, okay. Thank you.
All right. Is everybody, is that you consider that friendly?
Absolutely.
All right,
More
so
than
that's going to
friendly.
be accepted as a friendly amendment. All right, we're now ready to vote on the motion on the passage of the bill, which has been seconded. Is there any further discussion?
Do we need to vote on the amendment?
No, he accepted it as a friendly amendment.
Because we voted on the other one that he said was friendly.
Well, never mind. You're under Robbie's rules. All right. All right. All those in favor of the do pass motion, please raise your right hand. Of committee sub as amended. As amended twice. That's fine. All those opposed? 1. All right. Thank you for letting me get away from this microphone.
I'm not sure they would come see us, though. That's the problem. That completes the agenda. Diane? That complete it? Okay. Belated, I'm sorry, Senator Pearson, who is going to handle this for you on the floor?
Well, I prior talked to Representative Mills, but I'll give him an opportunity to reconsider that.
I think he'll do great. Representative Mills, thank you. Belated recognition of Judge Stevens, who we're glad to have with us today. Judge McGarrity was here earlier. Sandy, tell him that I just got off on a bill and didn't recognize him. Anything else to come before the committee? If not, we will be adjourned and we will meet again sometime next week. No meetings tomorrow. Yeah, I'm sorry, Representative Abrams.
I would just like the committee to recognize that the chairman's having a birthday tomorrow.
Well, thank you, Representative Abrams. Thank you very much. He's Did I have to hear Tom Knox sing? Well, thank you all very much. Thank you very much. Oh. Oh, thank you all so much.